The first one is around non-competes. And this is actually a federal law. So this is not just with the state of Colorado, but a federal law. And so, John, do you want to give us an overview of what this law is?
Yeah, sure. So, last year, Colorado put limits on non-competes and non-solicit agreements. But now the Federal Trade Commission has issued a final rule that is basically invalidating non-competes nationwide. And that is set to go into effect in early September, September 4th, at least right now. So basically, except for senior executives, those non-competes are no longer enforceable, and you can't enter into new non-compete agreements. So basically, if you have any of those agreements, you should be reviewing them with your legal counsel, and you should be notifying your employees that they are no longer valid.
And they've always been really hard to enforce anyway.
Yeah,
So,
notoriously difficult to enforce with employees
yeah.
and former employees.
Exactly. So it's not, for most of us here listening, like this isn't a big deal. It's just really important though that for you to know that you don't need to do that paperwork up front because it's not no longer valid. And so it just sort of, creates one less step that you have to do when you're onboarding or you're orienting someone into your new company.
Yeah. Now, you can still have non-disclosure agreements, particularly to protect trade secrets. And that's where you really want to focus, is if there's any proprietary information or intellectual property that you feel really strongly about protecting, non-disclosure agreements are still something that you can have in place. It's just often those have been intertwined with non-competes or non-solicits, and now you have to really pull that apart.
Yeah, and there's a good reason to have the non-disclosures. So, for example, just as a reinforcement here, when you go to terminate someone or someone leaves, it's a really good idea to have a non-disclosure in place to protect the organization, protect your clients, and just kind of reinforce that they're not allowed to say bad things about you, they're not allowed to disparage you. I mean, whatever else you might want to be putting into the non-disclosure, right?
Yeah, I mean, a good separation agreement will have a non-disclosure, will have that non-disparagement clause in there, which in Colorado, actually, again, last year, there's specific language that you need to have. So that was all part of the Power Act. So if you have any old separation agreements that you're kind of recycling, you should have your legal counsel look at those again, too. And I believe in those separation agreements, particularly when you're dealing with upper level leader positions or anyone who's on the front end working with clients or sales. You want to have one of those agreements in place because you don't want ill will affecting your employer brand out there in the community. So any like investment that you would make in terms of providing a small severance gets you that separation agreement, gets that non-disparagement clause in there, and an NDA around trade secrets. And that's the thing that you really want in place, as well as to have both sides feel like they're exiting the relationship without any ill will.
Perfect. That's great. So if you want more information on that law, just reach out. We'll include it in the show notes as well. And so you'll see a link here in the show notes if you're listening. And then if you're up on YouTube, we'll put it in the YouTube comments as well.